Hearsay is one of the most complicated rules of evidence in the law. Hearsay is defined as any out-of-court statement that is offered for the truth of the matter asserted. However, as hard as that is to understand, there are numerous exceptions to the hearsay rule. So in the context of today's testimony in the January 6th hearings, there was testimony by Mark Meadows' aide, who testified to things that she heard people say during the protests or riots on January 6th at the United States Capitol. People are saying, well, that's hearsay, that's hearsay. Based on the exceptions to the hearsay rule, there are numerous exceptions to the hearsay rule that apply to these statements. The first of which is they are not necessarily offered for the truth of the matter asserted. So when she said Donald Trump said he didn't care if they had weapons, that is not offered for the truth of the matter asserted. It's offered for the fact that he knew that they had weapons. So that is his state of mind. The other exception is that he is making a statement against his own interest. So if he becomes a defendant in a case, they can use those statements against him because he is the defendant and it is a statement against his own interest. It could also be considered as an admission, and it is a statement of a party opponent. So there are 4 potential exceptions to the hearsay rule with respect to Donald Trump's statements, Mark Meadows' statements, and many of the statements that were overheard during the insurrection on January 6th. There are many other exceptions to the hearsay rule. There's the dying declaration. If somebody says something on their deathbed, there's the excited utterance. Somebody just blurts something out in the intensity of a moment. And there are other exceptions to the hearsay rule, statements of a co-conspirator. So it takes a really long time to understand hearsay, even in the context of law school. It is one of the most complicated concepts to grasp. But oftentimes people just say, oh, well, that's hearsay. But if somebody saw something and they testify to it, that is not hearsay. That is witness testimony, firsthand percipient witness testimony. When it comes to statements that somebody hears that are out of court, meaning that they're not subject to cross-examination, then the whole list of exceptions come in. And that's hearsay in a nutshell.